Mrs. Dean, are we live?
Yes, we're live.
Let's go on the record on cause number DC 19-16772, Macias versus CW Construction. Council, make your appearances.
Barrett Beck for plaintiff.
Todd Wright for defendants.
We're here on a motion to strike. Why don't we proceed?
Yes, sir. And Your Honor, before I proceed with this motion, I wanted to bring it to the court's attention that I believe back on February the 1st, we had a hearing on plaintiff's motion to strike 4 counter affidavits of Gregory money, which was granted. And per your instruction, I sent the order to the court coordinator, Ms. Rhonda Penson, and I just wanted to bring that to your attention. And
have I already signed it or not?
I checked the clerk's website this morning and I didn't see it. It may be signed, but just not uploaded to the website. But
Let me double check. It's always possible that. Okay, so what day did you think that came in?
I think it was February the 1st, 2021, just about a month ago.
Yeah, I think you're exactly right. I'll go ahead and sign that right now. Reagan, do you mind grabbing that? Okay. Okay, so we're going to sign that. Go ahead and go forward with this motion.
Thank you, Your Honor. Now, we asked for 60 minutes today, but I don't think it's going to take that long. Our arguments are pretty universal across the board. This is a motion to strike counter affidavits by 7 different doctors, and there are 12 total counter affidavits. And what I'd like to do, Your Honor, is address them in order as they're attached to plaintiff's motion. So starting with Exhibit A and kind of working my way down. Before I pinpoint, each one of those counter
First off,
affidavits.
let me just ask this: are all of these timely?
Yes, Your Honor. We're not arguing that they're untimely, and we're not arguing qualifications either. We're just arguing that the defendant's counter affidavits failed to give reasonable notice to us with respect to the arguments they are going to make at trial. It's our opinion, or it's our argument, that the counter affidavits contain conclusory opinions that fail to provide or disclose the factual basis of what they purport to represent. And that's illustrated in each one as we go down the list. And it's our argument that, yes, these experts are qualified. However, there's a lot of Ipsy Dixit. The requirements under 18001 asks for a higher burden than, say, a plaintiff's 18001 affidavit, and qualifications plus Ipsy.
I'm very familiar with the law in this area. So the first one is the counter affidavit of Dr. Duvall. Is that correct?
Yes, sir. Wesley Duvall. He's a chiropractor, and that's Exhibit A is the first one that I would like to look at.
Okay, I'm looking at it right now.
So I'd like to direct your attention first towards the bottom of page 2, that paragraph down there. And you'll see this throughout the counter affidavit, a lot of references to Medicare and Medicaid and Texas workers' compensation and other types of reimbursement rates that are inapplicable to this case.
Right.
Ms. Macias is not a Medicaid recipient, Medicare recipient. She wasn't hurt on the job. And, these collateral sources, it's plaintiff's position that these collateral sources are irrelevant to the case.
I agree with you. I don't ever consider Medicare, Medicaid, or workers' comp, but it looks like that he's okay. Any amount billed higher than the amount determined to be reasonable to charge for self-payer is considered excessive and therefore not reasonable, regardless of what benefits may or may not be available to plaintiff. Mary Louise Macias, and regardless of what agreements or guidelines may or may not exist, determine amount should be charged to plaintiff Mary Louise Macias for the services provided by Texas Radiology LLP. My analysis in this case was performed under the assumption that plaintiff is a self-payer, and the amounts I determined to be reasonable charges of the open rates I believe are reasonable to charge a self-payer based on my knowledge and experience in private practice. I mean, I think that's the right analysis, at least.
And Your Honor, if I may interject for just a moment, none of these doctors say that the Medicare or Medicaid reimbursement rate is the threshold. None of them adopt that as the reasonable charges for these services. It is an element of the analysis, but it is not the sum and substance of their opinions. None of them adopt that reimbursement rate as the reasonable charges.
Your Honor, I would disagree with that. If you look at page 5, the first full paragraph on page 5, it says, "It has been my experience in private practice that a charge equal to approximately 140% to 170% of the charge allowed by Medicare is typically in the range of the open market rate that is reasonable to charge a self-payer." And, you know, those are, that says it all right there. And this expert is relying on irrelevant collateral sources.
And I don't want to belabor the point.
Yeah. So again, I've only just kind of glanced at this. I saw that this was probably going to take a while. I kind of glanced through these beforehand, but so, you know, I admit I try to be very formulaic about how to deal with these because we see so many of these motions. So I always strike non-medical providers. So that's why I struck Mr. Money. And then I look at, I don't consider Medicare, Medicaid, workers' comp, because that's an apples and oranges comparison. So it has to be like to like. So this one kind of gets through the chiropractic, you know, it's like, it seems to be like to like, it's not used, it is a medical provider. So the way these usually get through, if they get through, is if the doctor does an analysis of what a self-payer would pay in the marketplace of Dallas County. And it seems like, but I may be missing something in here, that what he did is just say it's 140 to 170% of Medicare, and that's the amount. And therefore, this wasn't reasonable because it was above that amount. Is that what this doctor did?
That's plaintiff's argument, but, you know, I'm sure Mr. Wright has, you know, something else to say about that. So go ahead, Mr. Wright.
Yes, Your Honor. None of these doctors adopt the Medicare, Medicaid, or workers' compensation rate as the reasonable charges. They all reference that as an element of their analysis, and they are all familiar with and have generated charges in their practice for similar services for similarly situated self-payers. And yes, they use that as an element of their analysis, Your Honor.
Okay, but do they explain why it is my experience in private practice that a charge equal to approximately 140, 170 of the charge limit? Where do they get that information? It's expressed in their reports, Your Honor. But have they done an analysis of like, okay, I've contacted, you know, Dr. Smith, Dr. Jones, and Dr. Garcia, and when they're charging self-payers, they charge 140 to 170, or does he just say, this is my experience, it's 140 to 170 of Medicare?
It is based on their experience in the practice that they have conducted and the facilities they have been at. And
does it say that in the report or not? I don't see that in the report.
There are, let me get to the. On the first page, for example, of Dr. Duvall, page 1 of 7, at the conclusion of that paragraph, Dr. Duvall says he has routinely determined the usual, customary, and reasonable charges for many types of chiropractic and diagnostic imaging procedures and services. He has ordered the same. The next page, the second paragraph on that page, says he's ordered the same services and procedures as those provided.
Your Honor, that's still Ipsy Dixit. I mean, I'm an expert, so whatever I say is right. You know, that's not the standard here. So if there's nothing more than that, then it's.
I agree that statement's not enough. Is there anything else, Mr. Wright?
Throughout the report, on page 4 of 7, the largest paragraph here, the doctor goes through all the bases, including the Medicare, Medicaid, workers' compensation, CPT codes, his familiarity with charges in the Dallas-Fort Worth area for those charges, publications from the Texas Department of Insurance, Fair Health.
Okay, yeah, that's not going to do it either. All right, I will say this is a good faith effort. This is very close to what would get through, but I don't think it just generally, Mr. Wright, and I appreciate you making an effort here. The more that the doctors are going to refer, the counter affidavit doctors are going to refer to Medicare, Medicaid, and other, third-party payers as some kind of benchmark. I don't buy that. So I'm going to go ahead and strike Dr. Duvall. Let's go to the next one. Are they all kind of the same, or do they have a different basis for each one?
So Dr. Duvall has 3. Exhibits A through C are by Dr. Duvall. So looking at Exhibit B, it's a counter affidavit with respect to plaintiff's 18001 affidavit from Premier Injury Clinic. And let's see if I can get to Exhibit B. If you're looking at the PDF with the 148 pages, it starts on page 22.
22. Okay, that's helpful.
Yes, sir. So I mean, it's plaintiff's contention that it's pretty much a form counter affidavit that goes through the same type of analysis, referring to collateral sources and providing Ipsy Dixit opinions. And looking at this one in particular, if you look at page 5 of 7, the first full paragraph, he gives that same sentence we're stating the 140 to 170% range, 140 to 170%.
It looks pretty much identical. Is there anything different about this one, Mr. Wright, that I need to look at?
They are substantially similar, Your Honor.
Okay, so I'll strike this one as well.
And then the last one by Dr. Duvall, Your Honor, let's see, it starts on page 34, Exhibit C.
Okay.
It's pretty much the same thing here. The same sentence, that same range, the 140 to 170% range, correlating to Medicare is on page 5 of 7, first full paragraph.
Okay. Is it kind of the same, Mr. Wright?
It is substantially similar, Your Honor.
All right, so this one will be struck.
So those are the counter affidavits by Dr. Duvall. And that would take us to Dr. Keith Lepak, who's an emergency room physician. And he has two counter affidavits. The first one is Exhibit D. So you're on page 45.
Mhm.
So similar arguments by plaintiff, Your Honor. Looking at page, I believe it's page 48 or 4 of 7 of Exhibit D, or PDF page 48. If you look down at the bottom of that page, he gives the same type of sentence that.
Wow. They all say the same thing, 140 to 170. Okay.
Yes, sir. This counter affidavit is substantially similar to Exhibits A through C.
Is it substantially similar, Mr. Wright? Anything
It is,
different?
Your Honor.
All right. This one will be struck.
And then that takes us to Exhibit E, which is Dr. Lepak's second counter affidavit. Looks like it's on PDF page
There we go. 60.
Yes, sir. And
Is this one also substantially similar?
yes, sir. Same sentence is at the top of page 5. 140 to 170% of Medicare.
All right. This one will be struck.
That takes us to Dr. Sunil Thumala's counter affidavits. There are 2 of them. Exhibit F is with respect to Hypnic diagnostics.
Is it the same 140 to 170?
I'm looking.
Yeah,
to
still, yeah,
see-
it is. Yeah, I see it on top of the page 5.
Yes, sir. I see it too.
All right. This one's struck as well.
And that takes us to Exhibit G.
It's the same thing.
Yes, sir. I mean, I don't want to speak before I see the 140 to 170. Here it is, top of page 5 again. 140 to
Yes,
170.
All right, that one's struck as well. Now I see there's one involving Eric Davis. Is that same thing?
Yes, sir. If you look at page 5 of 7, the first full paragraph,
I
it
see it. Yeah, it's struck as well.
takes us to Exhibit I. Sorry for all the clicking if that's annoying.
I mean, are all of them the same? I mean, is there any of them that are different that I hate to waste y'all's time because I'm ruled the same way if they're all the same 140 to 170.
They are not, Your Honor.
Okay, which one is different?
And
This one is not. This one's 140 to 180% of Medicare. It's at the bottom of page 4. So it's 10% difference.
All right, this one is struck. Okay, which one is different, Mr. Wright?
Your Honor, that may have been the one that leapt to mind.
Exhibit J gives the same 140 to 180% of Medicare.
Struck as well.
Leaves K and L left.
Is this also one of the 140 to 170 ones?
It's
Or
gonna
141.
be one or the other.
okay. Yeah, it's struck as well.
140 to 170, Exhibit K. And then L,
So what
L,
are,
140 to 170 at the bottom of page 4.
so let me just say one other thing, because So what are your total medicals in this case?
It is about $675,000, Your Honor.
God, okay.
And Your Honor, I think, the concern on our end, is of course by granting the motion to strike all these affidavits, and it precludes defendant from even having the opportunity to challenge those issues. Plaintiffs have then, by statute, met the minimum burden of their evidentiary threshold through cost clerks who have filled out affidavits, and we do not have an opportunity to even challenge these just crushing charges when this case finally gets to trial.
Well, Your Honor, they most certainly do. They can take the doctor's depositions and cross-examine them on why their charges are reasonable, or usual, customary, and reasonable in the Dallas area.
Let me make one other thing clear. I'm not striking these counter affidavits. I'm not striking the doctors who prepared those counter affidavits as experts. They can still testify. But the other thing I would say is that Mr. Beck just it was